No mai haere mai, tēnā koutou katoa. Welcome everyone to webinar 16 in LDAC's ongoing series on legislation guidelines. Today we're looking at infringement offences. Infringement offences can be a very effective tool, but their impact depends heavily on careful and well-considered design. Today's webinar takes a practical look at how infringement offence regimes are used in legislation and the key issues to watch out for when designing them. We'll be drawing on Chapter 25 of the LDAC legislation guidelines, which deals with creating infringement offences and also touching on wider compliance and enforcement context, because infringement offences should be considered not in isolation, but as part of a broader regulatory system. We're also going to draw on the Ministry of Justice perspective, including the policy framework for new infringement schemes, which sets out Cabinet expectations for schemes to be fair, equitable, consistent and proportionate. To be more specific, today we will cover when infringement offences are appropriate, trends in their use and penalty levels, risks with overuse, overlapping regimes and poor design, and we'll finish by looking at designing a clear, workable infringement regime at the end. First of all, let me introduce myself. I'm going to be your facilitator today. My name's Guy Beatson. I'm Deputy Chair of LDAC and a freelance consultant focusing on governance, leadership and policy design after a long career in policy and strategy roles in the public sector, which included translating policy into legislation. And for my sins, I'm now a part-time ski instructor. In our webinar today, we're going to have three parts. One will be a short presentation from me about LDAC. We'll do a panel discussion with some infringement offence experts, and we're going to finish off with Q&A from you, the audience. And on that last part, we encourage you to ask questions and ask them when they occur to you. Don't wait until the end. We can just pick them up as part of our Q&A session. You can do those, or you can ask those questions using the Q&A button at the top of your screen, and we'll get to as many of those questions as we possibly can. But before we go on, I'd like to ask Sam and Chris to introduce themselves. Perhaps we'll go to Sam first and then to Chris.
Thanks, Guy. Kia ora koutou, ko Sam Miles toka ingoa. I'm a public service member of LDAC and I'm a policy manager in the local government portfolio in the new Ministry of MCERT. So that's Ministry of Cities, Environment, Regions and Transport. Kia ora.
And to Chris.
Thanks, Guy. I'm Chris Hurd from the Ministry of Justice legal team, and way back in 2005 as a fresh-faced young policy advisor, I worked on the Law Commission's review of the infringement system, and that came about from concerns about the proliferation of infringement regimes, and at the time we frequently referred to the fact there were 24 different statutory infringement schemes, and now there are 69. And so that's why this is an important subject.
That's great. Hey, thanks, and good to have you both with us. Before we just get into my conversation with Chris and Sam, I thought it might be just useful to talk a little bit about what the Legislation Design Advisory Committee is and what it does. So the Legislation Design Advisory Committee is made up of members appointed by the Attorney General to support good legislative design. It's a mixture of public service and non-public service members, so I'm one of those non-public service members. All members are voluntary or unpaid for their LDAC work. In the case of the public sector employees, their time is loaned by their employer, with the Department of Crown Entity or similar. Fortunately, the Parliamentary Counsel Office provides secretariat support, including advisors to support the committee and also help us with webinars like this. Members have a broad range of backgrounds. We draw members from legal and policy teams within departments, Crown entities, and as well as academics, lawyers and barristers and consultants. The reason we've got a broad range of skills and experience is that's important because good legislative design is multidisciplinary. It's not just about the law, which is why you end up with people like me with economics degrees involved as well. LDAC has three functions. We publish and maintain the legislation guidelines and supplementary material. That's the government's handbook for good legislative design. The most recent edition was updated in 2021, but the guidelines have a decades-long history and are direct successors of the Legislation Advisory Committee guidelines from some while ago. Second function is we carry out education and engagement activities like this session today, but we also work individually with departments and on specific issues. Beyond those activities, they extend beyond the advice function we've got. So it's common to see submissions to select committees refer to the guidelines, and ministers are required to address consistency with the guidelines in cabinet papers for bills. Our advice function applies at two different stages. The bulk of our advice work is prior to introduction when we advise departments that come to us, and we also make submissions to select committees. Second thing I just want to touch on is how can LDAC help? The issue for us and the way we help is by not focusing on the policy. It's important in that context to remember that guidelines are just that. They're guidelines about how to translate policy into legislation. They're not rules that must be followed. So the bottom line out of all of this, in terms of how LDAC can help, the goal is to ensure that there's conscious design choices for legislation that are being made. So now that you know a little bit more about LDAC, I'll stop sharing that. We will now get into our webinar about infringement offences today. And we're really fortunate to have both Sam and Chris with us, and just to bear out a little bit of their introductions. Sam, because he's a member of LDAC, is going to speak to the guidelines and LDAC's legislative design perspective. And Chris, given that history, is going to bring not just that Law Commission experience, but also the Ministry of Justice perspective and practical experience with offence and penalty design. So, with that introduction out of the way, let me turn to Sam. First part of what we're going to talk about is what infringement offences are and when they should be used. So, Sam, could you start by explaining for us what an infringement offence actually is?
Thanks, Guy. So, yes, by way of introduction then, an infringement offence is a particular kind of criminal offence. And given it sits within a criminal law framework, it does need to be treated with some care when designing an infringement regime. So the typical model is the person in breach receives an infringement notice which requires payment of a fixed infringement fee. On payment of the fee, there's no further sanction, so no conviction or prosecution. And the legislation guidelines set out when infringement fees should be considered, which really they're appropriate for conduct that is, it justifies a criminal sanction, but not the full force of a criminal law prosecution. So there's no conviction, imprisonment, or a significant fine. The key point is this is an enforcement tool, so the starting point is to consider what the conduct is that's being addressed and whether an infringement fee regime is an appropriate response. In the guidelines, it gives some examples, and some of the features that make an infringement regime appropriate are it's offending, but it's a minor level of offending. Often where it is potentially a high volume of offences, and that the assessment of facts, they're relatively straightforward to identify. So there's no complex issues of fact and relatively straightforward for an enforcement officer to understand when to apply an infringement. And also, obviously, there's a fixed fee, so the conduct should be similar enough in nature that it's suitable for a fixed fee. And typical example, of course, is traffic offences such as parking tickets and speeding tickets. And in preparation for this, Guy, I got myself a speeding ticket about a week ago. So I've got an infringement notice, just doing a bit of practical research there. And obviously, straightforward facts, straightforward breach, deserving of sanction, but not one that should go to the courts because it's not an appropriate response.
So you've nicely narrowed the paddock in which infringement offences can roam, essentially, having had that practical experience as well. Now, if we're going to talk about practicality, I guess I'll turn to Chris. And I think it's worthwhile just exploring when an infringement offence is most useful in practice. Do you want to talk a bit about that?
Yeah, thanks, Guy. So infringements, they're most useful where the conduct is low level enough. The prosecution would be disproportionate, but you still really need the rubber to hit the road. You need some real incentive to comply. They tend to work well where the breach is easy to detect and prove. If the offence is complex, you're more likely to get challenges, and that's what a good infringement system is designed to avoid. They're particularly useful as was said earlier, in high volume regulatory systems, the courts wouldn't cope if every traffic offence had to be prosecuted. But of course, convenience isn't enough. Infringements are a criminal sanction, albeit a low-level one, and they need to be an effective and proportionate response to the harm. The question is always, is this the best way to achieve the desired outcome? You need to be careful about over-criminalising. You don't want to create a sanction for something that's better dealt with other means, such as education. But at the other end, you don't want to use an infringement for something that really warrants prosecution because of the complexity of the offence or the seriousness of the conduct.
Yeah, that's right. I mean, it's kind of interesting, isn't it? I mean, the idea that says, quite like what you said about the fact, this is just not about administrative convenience. That came up in another conversation I was in earlier in the week. So that really helpful description of the practical conditions for when infringement notices work well. And I guess to build on that, Sam, could you explain for our audience how infringement offences fit within the wider compliance and enforcement toolkit?
Sure. So the legislation guidelines cover a range of enforcement mechanisms, which infringement offences should be considered in the context of the overall design of the regulatory system and the means of enforcing. So in the guidelines, Chapter 25 deals with infringement offences, but it's also important to consider Chapter 22 on ways of achieving compliance. And so that means infringement offences really sit for matters that are less serious than criminal prosecution, but then sit alongside or above where issues might be dealt with through warnings or other softer regulatory tools, such as engagement and education. Now, one of the points to note here is that often a well-designed regulatory system will have a graduated enforcement model, and we'll come on to the questions during the discussion of the risk of overlap. But despite that, it's often a good feature of a regulatory system to have a graduated enforcement model. And one of the things to think about there is both the conduct and the consequences. So some examples in the legislation, I think, are the Animal Welfare Act, which provides for graduated responses for first, second and third offences. And also in recent local government water services legislation, there's a differentiation between conduct, the consequences. So if conduct that causes a serious risk of harm is prosecutable, but where the risk of harm is less serious, it can be suitable for an infringement offence. So from LDAC's perspective, the key thing is where the same conduct can trigger a different enforcement response. The legislation needs to be really clear as to how the tools work together.
Yeah, and that seems to be the key, right? And we don't want to have uncertainty for regulators or unfairness for the regulated parties either. So in this first piece of our webinar today, we've talked about what infringement offences are and when they should be used. The key message from this is that infringement offences are useful but limited. They are generally for lower level, high volume, straightforward breaches where a fixed monetary penalty is a proportionate way to encourage compliance. And Sam's referred to Chapter 25. So this is where Chapter 25 links back to Chapter 2022 of the guidelines. Infringement offences are not just an offence design issue. They are part of the wider question of how a regulatory system encourages compliance in the way that Chris was talking about and responds to non-compliance. They should not be treated merely as an administrative or convenient way of achieving the outcome. They are still part of the criminal law. They need to be justified as part of the overall enforcement design. The practical starting point is to identify the conduct, the harm, the regulated group, and the compliance objective. Only then should agencies decide whether an infringement offence is the right tool. And just before I move on, if you have a question that's come out of the thing we've just discussed, please use the Q&A button at the top of your screen and we'll get to as many of your questions as we possibly can. So we want to move on now to talk about the risks of overuse, overlapping regimes, and penalty regimes. I'm going to turn first to Sam. What are the main risks LDAC sees when infringement offences are proposed?
Thanks, guys. So as you say, there's really three main risks that we'd look at, and the first is overuse. Um, because infringement regimes are seen as efficient and administratively simple, there is a risk that it can become a default or a starting point mechanism. And as we've discussed, it's important to consider an infringement regime in the context of the overall regulatory system rather than looking to that as a starting point. The second risk, if the design of the regulatory system isn't considered carefully, is that the infringement regime might be either and it might be a disproportionate response, either too strong or too weak. So where it could be seen as being very heavy-handed if conduct that shouldn't be subject to any criminal consequences is brought into an infringement regime, and conversely, if very serious offences are not suitable for an infringement regime, and so having a differential of what is infringement is prosecutable. And thirdly, what we've already touched on is the question of overlap, and it may be appropriate to have different enforcement responses for the same conduct, but this is where it's really important to design it right. And the risk is if there's too much discretion for the regulator, that can create uncertainty. And as you mentioned before, Guy, I think there's a question then of fairness for the regulated party. So starting point is for infringement regime, as for all law, is it should be accessible, which means it's understandable, it's clear, and it's predictable in how it will be used. And so from an LDAC perspective, it should be clear for the regulated party as to what the consequences of breach are, and in a coherent framework.
That makes perfect sense, right? And the idea of actually fitting in with everything else is a core message we want to get across this morning. Chris, you talked, and I think Sam's talked about this too, in terms of fee levels and being consistent and so on and so forth, and you've talked about incentives. Do you want to talk a bit more about what issues arise with infringement fee levels?
Yeah. So setting appropriate fees is an important part of designing an infringement regime. In fact, it might be one of the factors that actually helps you determine whether an infringement regime is actually the right option for what you're trying to do. The fee itself, it serves two purposes: deterrence, and if that isn't successful, holding the person to account, or in less PC terms, punishment. Talking about deterrence first, you want to set the fee at a level that deters the majority of your target population. Of course, that depends on who your target population is and what it is that you don't want them to do. A relatively low fee may deter an individual from driving too fast, like Sam. Getting there 3 minutes earlier isn't worth $120, but you may need a higher fee to deter a company from doing something or not doing something that's going to increase their profit, because otherwise it just becomes a cost of them doing business. But deterrence isn't the only consideration. The fee also has to be proportionate to the harm and consistent with the penalties for similar conduct. If the fee you need for deterrence purposes is disproportionate to the harm, then you've got a bit of a problem. While we're talking about proportionality, it's important to remember infringement fees are a blunt instrument. They don't adjust to the individual circumstances of the offence and offender. So you need to think about practical things like time to pay arrangements for people on low incomes. Another issue is what to do about repeat offending. An infringement fee is set to deal with a one-off offence. If the person keeps doing it, the fees can quickly become disproportionate to the actual offending. An extreme example from the early 2000s, from my infringement review days, is Nathan Bentley. By 21, he'd accumulated over $90,000, mostly in infringements for little things like no warrant of fitness, no rego, riding a bike without a helmet. He was just an antisocial young man, and what he'd done wasn't worth anywhere near $90,000. But the regimes he was dealing with just didn't adjust to that. The Employment Relations Act 2000 has an interesting way of dealing with repeat offending. It limits the infringements that an employer can receive in a 3-month period to $20,000. So that's one option, but the point is you need another option for repeat offending. That may be prosecution, it may be something else. The LDAC guidelines note that infringement fees are generally expected to be under $1,000, and higher fees need particular justification. Agencies should engage early with us, the Ministry of Justice, if they're considering fees above that level. Also remember, you're trying to avoid litigation, so the higher the fee, the more incentive to challenge. As I said, there are currently 69 statutory infringement offence regimes. The majority of those regimes provide for infringement fees of about $1,000 or less for individuals. But of course, there are some regimes that are more. The Financial Markets Conduct Act 2013 has fees of up to $20,000 for commercial contexts. But those kind of fees are very rare. So wrapping all of that up, in setting the fee, you need to think about things like your target population and the fee it will take to deter them, whether your proposed fee is proportionate to the harm and consistent with penalties for similar offences, how to deal with repeat offending, and practical things like time to pay if affordability is going to be an issue.
Yeah, it's interesting, isn't it? I mean, your example highlights the fact that the audio or the target group really matters. I mean, the $20,000 infringement fee for the companies involved in the FMCA is kind of, that seems obvious, but it's not quite the same for Sam's parking fine. There's all of that going on. So the point about fee levels is also a useful bridge into the next issue I want to canvass with Sam. If the fee has to do too much work to achieve deterrence, that might be a sign that the regime's not using the right tool, or that the relationship with other tools needs to be clearer. And Sam, you touched on this before a little bit, but I want to explore this just a bit more. How should agencies think about the overlap between infringement offences and other enforcement tools?
Yeah, starting point is to have a really good understanding of the regulatory system overall, and how infringements sit in those enforcement mechanisms. And if you've got that understanding based on what's the conduct that you're trying to deter and what's an appropriate response, then it means overlapping responses and different enforcement pathways. They're not necessarily inappropriate. It might be an appropriate response. It just needs careful design and good thinking through and understanding the system that you're working in. So that requires clear legislative material. So from the legislation, it's clear for regulated parties what the consequences of breach are. And also this is an opportunity to think about the supporting policy material, and whether regulator policies are required to supplement legislation to ensure that people can clearly understand the consequences. As we talked, really, those overlaps can be justified either by the nature of the conduct or the likely risk that results from it. So there's some examples where there's a difference between negligent conduct and reckless conduct. And also, as I think I mentioned earlier, about the seriousness of the risk that might result. For example, this was in the water services legislation that's recently been passed, and it's about how serious is the risk of putting things into the water system that shouldn't be there. So the risk really of overlap is if there's uncertainty as to what the response is going to be, and it creates unpredictability. And importantly, there's then a risk of inconsistent treatment, and that goes to the question of fairness. So from an LDAC perspective, when things come to us, what we'd look at is it clear what the different distinct roles of each enforcement pathway are? Are those escalation points clear? And is it certain for the regulated party to understand what the consequences of non-payment? And if those things are in place, then that's great. And if not, there's probably a little bit more work to do.
Yeah, it's really important, right? I mean, because none of this is hard and fast. That's why, in my introduction, I'm talking about the guidelines being guidelines because there are different circumstances around that. Now, having said that, I suspect, given your experience, Chris, there are particular warning signs that an infringement regime is poorly designed. And given you and your colleagues' experience, you've probably seen a bit of that. Do you want to talk a bit about what those warning signs are, Chris?
Yeah. There's definitely warning signs. So the whole idea with infringements is the conduct isn't serious enough for a prosecution. So you want to avoid complexity because complexity leads to litigation. Infringements work best with strict or absolute liability where there's no mental element. They also work best where the offence and the potential defences are straightforward and clear. The more complex the offence, the more likely people are to challenge it, meaning you've lost the benefit of having an infringement offence. Another issue is where the regime doesn't follow the standard process for infringements in Section 21 of the Summary Proceedings Act, which covers things like reminder notices, challenge rights, and enforcement of unpaid fees. The guidelines indicate this process should apply to all new infringement offences unless there's a strong justification for doing something different. The Section 21 process has been around for a long time and it's pretty well understood by the public, including Sam. So just don't rock the boat. And finally, in keeping with the simplicity theme, there can be issues with the legislation where the legislation leads too much to operational discretion. You want consistency and certainty, or you're opening yourself up to challenge.
It's really interesting, right? So far in the webinar, we've talked about what infringement offences are and when you use them. In this session, we've talked about the risks of overuse, overlapping regimes and penalty regimes. And I guess, to pull that all together, and the key message from what we've just been talking about is infringement offences need to be used deliberately. They aren't the default option for any regulatory breach. They are most appropriate when the conduct is minor, straightforward, and suitable for fixed monetary penalty. The warning signs, and Chris has touched on these, we've discussed, can be used as a practical diagnostic. Unclear conduct, a penalty level doing too much work, unclear overlap with other tools, or departure from the standard process without a good reason are pretty strong red flags that need to be looked at. The penalty level is central. It must be high enough to encourage compliance, but still proportionate to the conduct and fair to the people affected. We've also heard that the overlap with other enforcement tools needs careful attention. Sam covered that off. A regime can have a range of tools, but these tools need to work together as a coherent system. Those are all signals that advisors should step back and test whether the proposal is coherent as part of the wider enforcement system, rather than treating the infringement notice as a standalone solution. For policy and legal advisors in our audience today, this means testing the infringement proposal against the wider enforcement framework, not just asking whether an infringement notice would be convenient. And I'm sure our discussion will have raised some questions for you. If it has, then please use the Q&A button at the top of your screen, and we'll get to your questions in the last part of this webinar. So as we move into our third section of the webinar, we're going to talk about designing clear and workable infringement regimes. So we've talked about a whole bunch of other stuff. Now, how do you do it is essentially the question around those. So I want to turn to Sam. What are the main things that need to be designed clearly in an infringement offence regime?
So, Guy, thanks. The important thing is to be able to explain an infringement fee regime in the context of the overall regulatory system. And there's a couple of key questions there. Is it clear what the conduct is? And is it clear what would amount to a breach and what the consequences of a breach are? And the next component is the enforcement mechanisms and the process. So you need to have clarity as to what's in the Act and what's in secondary legislation and what the enforcement mechanisms are. So what officers are entitled to issue infringements, what the process is, and what the mechanisms for challenge are. And I think Chris mentioned earlier the Summary Proceedings Act and mentioned that I think there's 69 infringement fee regimes. Now, infringement regimes should ideally point towards the Summary Proceedings Act for some of that process, and I think there's around 45 of them do, so not all of them are listed in that act, and that's an easy way to ensure a consistent process, and helps ensure that that enforcement pathway is clear. In terms of how infringement regimes can become complicated, I think there's a few examples in local government legislation. The primary one being that there is mechanisms in the Local Government Act for bylaws to be for infringement offences to be created for bylaws, but this mechanism is via an ordering council, and it would require each offence in a bylaw to be subject to an ordering council process. So it's too administratively complex to achieve that. And it's a mechanism that's been in legislation since 2002 and hasn't yet been used. So that's where your design might not land in practice.
Yeah, it's interesting, isn't it? I mean, it kind of and it gets buried in the another thing that's come up recently, which is if you're going to design one of these things, there actually better be an offence in here that actually you can have some sort of infringement notice, infringement offence associated with. So I just want to turn, Chris, now to the Ministry of Justice's perspective on the key limits or safeguards that you and your team are looking for when offence details are left to secondary legislation like this.
Yeah, thanks, Guy. Well, it's reasonably common for the detail of infringement schemes to be left to secondary legislation. And obviously this provides flexibility and means you don't have to go back to Parliament to make changes like increasing the fee for inflation. But infringement regimes are criminal in nature, and so the primary act should clearly establish the authority and boundaries of the scheme. That includes the existence of the scheme, who can issue infringement notices, the maximum amount an infringement offence can be, revenue arrangements, if that's relevant, and authority for regulations or bylaws to fill in all the detail. Regulations and bylaws can then specify things like which offences under the Act are infringement offences and what the fees should be for each offence. I'll just end with a reminder to consult the Ministry of Justice, as a plug for us. Consult us early on cabinet papers, bills and regulations for infringement schemes, because these schemes can raise all kinds of issues: criminal law issues, penalty issues, Bill of Rights issues, court process and system consistency issues. So yeah, definitely consult us early.
I was just thinking that's a bit like an advertisement from our sponsor. So thanks for that, Chris. What you've said aligns with the legislation guidelines on delegated legislation. Significant policy choices and limits should be in the Act, while regulations can deal with detail with clear authority. We've also got a separate LDAC webinar on delegated legislation if people wanted to explore that issue further on the LDAC YouTube page. So, having dealt with a message from our sponsor, how should advisors approach proportionality when designing infringement regimes, Sam?
Yes, proportionality is critical, and it's not just about the dollar amount of the fee. So, the starting point for proportionality is thinking about what's the conduct and what's the appropriate consequences for that. And it's in the context of conduct, the relationship between the conduct, the enforcement response, and the regulatory objective. So again, it's how the infringement fee regime sits overall in a regulatory system as part of a coherent package of enforcement mechanisms. And a good starting point is whether the conduct that you're addressing is sufficiently serious to justify a punitive response, but not so serious as it justifies a criminal prosecution. And when you're in that space, then an infringement fee regime is going to be potentially an appropriate mechanism. One of the things I think at that stage as well is it's really useful to look across at those 69 different infringement regimes that there are in the legislation, so you can have an understanding of achieving some kind of consistency, whilst obviously understanding that there's very different regulatory contexts. So, given that, it's a useful benchmark to see what's being done elsewhere.
Yeah, I guess, and with the absolute caveat that just because another legislative regime has an infringement offence regime doesn't mean necessarily the one you're working on should have one too. It's not just follow the leader in that sense. Um, so I guess that does lead neatly on to, though, the sort of safeguards that go around this. And I guess, Chris, could you talk a bit about what procedural safeguards should be built into any of these regimes?
Yeah. So procedural safeguards are really important with infringements because infringements impose penalties through a simplified process, which pretty much bypasses or at least defers some of the safeguards of a criminal prosecution. In essence, it's kind of flicking it backwards. Instead of being charged with an offence, going through a prosecution, and the prosecution having to prove the offence on the balance of, oh, sorry, not on the balance of probabilities, beyond reasonable doubt, you're flipped backwards and you're essentially assumed to have done the offence unless you challenge it. So procedural safeguards, the recipient needs to be clear about what's happening. They need clear information about the alleged offence, the fee, the payment options, timeframes, consequences of non-payment, because eventually it will end up being transferred to the Ministry of Justice in the courts and be dealt with as a court fine. They also need information about how to seek cancellation or transfer of liability or ultimately a hearing if they want to dispute it completely. I've already extolled the virtues of using the Standard Summary Proceedings Act process, so I won't go further into that here. The main thing is really that the process needs to be simple and work in practice. You're mostly dealing with members of the public. So the notices should be clear, the timeframes workable, and the challenge rights should be meaningful.
I think, Chris, it's interesting. I hadn't really thought about the feedback loop in terms of the ultimate collection of some of these infringement offence fines and fees, and the feedback loop to the Ministry of Justice. So there's quite a lot of incentive on you and your team to have departments get this right. We promised in this webinar something really practical, and I want to turn to Sam in terms of just if you could outline for us a practical checklist. Now, what would you suggest for policy teams before recommending an infringement offence regime?
Yeah, there's a nice short checklist with 5 points to consider. Firstly, what's the conduct that you're trying to deter? And as we discussed, is it minor? Is it potentially high volume? And is it factually clear and straightforward? Secondly, consider whether an infringement fee is likely to be a proportionate and also an effective response. So, will it be an effective consequence for the regulated parties? Consider your infringement fees in the context of the overall regulatory system and the other enforcement tools available, and how infringement fees might sit within that framework. Fourthly, understand the process, and is the process clear in terms of issuing infringement fees and rights to challenge, and is that clearly set out across legislation and secondary legislation? And finally, ensure that the right people have been consulted. Clearly, Ministry of Justice, Offences and Penalties teams and various other matters, and also to have that understanding of the regulatory system and the enforcement mechanisms that you might need and what will be workable in practice, which is obviously a very critical point, is have a good understanding of the people who'll operationalise the regulatory system you're designing and ensure you engage with them so that what you produce is workable and we don't have too much of infringement fee regimes designed that aren't used for many, many years because they're not actually workable in practice. So that's a really short checklist, and from LDAC's perspective, if those answers can be clearly explained, then things are looking good, and if not, then there's probably a little bit more work to do before moving on to drafting.
Yeah, it's the idea of it being workable and working through those checklists, and you suddenly find none of them kind of work, becomes kind of important, and go back to the not quite the drawing board, but certainly reconsider some of those key things. So we've talked about designing clear and workable infringement regimes. The key message out of all of this is good infringement schemes need clear authority, clear offences, proportionate fees, and workable procedures. Sam's emphasised the LDAC design questions: clarity, proportionality, coherence, and the fit with the wider enforcement framework. Chris, in his observations in response to my questions, has emphasised the Ministry of Justice system questions: legislative authority, fee setting, recipient rights, the Summary Proceedings Act, that seemed to have come up a lot, doesn't it? Enforcement and early consultation. Together, the test is whether the regime works fairly and clearly for both the regulator and the person receiving the notice. And if I wrap this up all together, thinking about the totality of what we've talked about in our panel session today, I hope it's given you a practical framework for thinking about infringement offences. The main message is infringement offences can be very useful, but only when they are used for the right kind of conduct and designed as part of a coherent enforcement system. They are generally best used for minor, high-volume, straightforward breaches where a fixed monetary penalty is proportionate and likely to encourage compliance, and that was a thing that Chris emphasised particularly. They are not suitable for serious conduct, complex facts, or situations where the real issue is culpability or intention. Penalty levels also need careful attention. They should deter, but they should need to be proportionate and consistent with comparable regimes. And finally, the process matters. The legislation needs to be clear about who can issue notices, what the offence is, what fee applies, how the notice can be challenged, and how the regime fits with wider compliance and enforcement frameworks. If you take one thing away, let it be this: infringement offences are a design choice. They can be used, and they should be used deliberately, tested carefully, and connected to the rest of the regulatory regime. So that pulls all the threads together. It's now time for your questions, and we've got quite a number of those. And I'm going to go with the most popular ones first, as we've published them. So I think I'm going to turn to Chris for this as a starting point. And the question's this: why are infringement offences necessarily a subset of criminal law? It goes on to say in a little bit of a novel, David Cunliffe managed to pass 2 civil infringement regimes in 2006-07, but since then no civil regimes have made it onto the statute books. Do you think that it is time to revisit this, particularly as criminal infringements lack the key criminal sanction, namely a conviction? What's your view of that, Chris?
That is a good question. I think it's ultimately about what is the nature of what you're trying to control, and really when you're looking, usually infringement offences are set in a criminal regime. They're part of a graduated kind of regime where you might have things like warnings at the lowest level, maybe then infringements, and maybe then prosecution, and that's covering the same conduct the whole way through. It's just different levels of it. So it seems a bit artificial if you're going to say, well, we're going to treat speeding as a civil matter in an infringement context, but we're going to treat it as a criminal matter when we're going to full prosecution.
I think it's really interesting. I think that there's a lot of academic literature around the difference between civil enforcement regimes and criminal ones, and particularly in terms of an increasing trend towards civil pecuniary penalties for regulatory business. But if we think about my speeding fine, it's a minor offence that doesn't justify court action, but it's conduct that justifies a sanction because the potential consequences are serious enough. So it's not a huge sum of money, but the fact that it attracts a criminal sanction reflects, I think, a community concern that if it was, here's a civil fine, it might have less weight on future behaviour, potentially.
Yes. So we've got a range of other questions which we'll just get to now. Um, there's a question, and you've thought quite a lot, I think, Chris, about the kind of the infringement fee levels, and I'm sure Sam's had some experience with this too. So go to you, Chris, first. What are your thoughts on the ratio between the infringement fee and the maximum fine, and the likely fine and cost if an infringement notice is unsuccessfully challenged?
Okay. So my thoughts about that are that if you challenge an infringement, I don't think you should be necessarily opening yourself up to the maximum fine. I think probably it should, to me, you should simply be the penalty is the infringement level, not the maximum fine on a prosecution. That to me makes more sense, because otherwise you're disincentivizing people to challenge.
Yeah,
Because the whole idea is that it's simple, and people will just, if unless they're certain that they haven't done this or whatever, that they will just accept it, pay it, and that's everyone's happy.
Yeah, no, that's right, and that goes to the heart of this whole thing being part of the kind of wider legal scheme as well. Do you have a view on that, Sam?
Oh, I've nothing to add. Thanks. I think
Right.
that's right.
So, I mean, I guess, and I'll move to you, Sam, just in terms of the next question. What are the legal consequences if someone breaches an infringement notice or fails to pay the infringement fee?
So this is where Section 21 of Summary Proceedings Act comes in, and if there's a failure to pay, then a court process to recover can follow through Section 21. And I think typically those regimes that don't point to Section 21 would have their own further enforcement mechanism within that legislation.
Yeah, no.
I just jump in on that.
Yep.
So yeah, once the prosecuting authorities filed it with the court for enforcement, then that opens up a whole range of options. If the person doesn't pay, there can be attachment orders to wages or benefits. There can be warrants to seize property. If it keeps going, you can eventually get, usually where people have accumulated a lot of them, you can get into the territory where the court has to decide whether to impose a different penalty, like a community-based sentence or something like that. You also get situations where people with large amounts of fine who are going to prison end up getting, another month tacked onto their prison sentence, and all of their fines get remitted. So,
Yeah.
so one thing, yeah, you kind of have to bear in mind is that infringements can actually introduce people to the criminal justice system in a kind of a roundabout way. You end up getting into it by not paying these low-level fines.
Yeah, but that goes to the heart of how the whole regime is designed, and actually thinking through some of that. So some of those scenarios where what you've described happens, Chris, and then if the regime hasn't thought those things through, then you end up in a rather interesting place, I suspect. I've got another question which I think kind of draws on this and kind of stretches it a little bit further. I mean, Sam, in the conversation we had, we were talking about overlapping regimes, but also kind of how the kind of thing stacks on each other and how various parts of a legislative regime actually works. And the observation here is I'm interested in the panel's thoughts on how to manage a regime that has both an infringement regime without a risk of conviction and a true is truly criminal for more serious offending with a conviction. And the questioner sort of says, well, one example of that might be driving with excess alcohol being, as an example, how to create a clear-cut distinction based on saying that the level of excess alcohol. What's your thought on that, Sam, in terms of having that kind of duality? Undoubtedly, the conduct's kind of the same, but the seriousness of it is different, and one attracts kind of that infringement offence side of things, and then you've got criminal conviction for other parts of that above a certain level. What's your view of that?
Yeah, I think there's a number of aspects to consider, and it would come back to what's a proportionate response, and maybe the first question we talked about, why there's criminal consequences for an infringement fee regime, and the overarching issue there is where it's conduct that's minor, but still there's an element of culpability. So in terms of an infringement regime versus prosecution, I think there's always going to be edge cases, but really where you draw an infringement fee regime is where the sanction itself, or the fact that it's a sanction, is adequate to deter in most cases. And we've talked a little bit around that can either be the conduct, but it can also be the consequences. So if the consequence of the conduct are more serious, then that would push it up into the prosecutable threshold. So it comes back to understanding, having a coherent set of enforcement tools and managing that overlap between the two is complex, and it probably is an issue that both requires the things we've talked about at the outset in terms of careful design, engaging with Ministry of Justice, and understanding from operational colleagues how it will be operationalised in practice. But it also goes to the regulatory stewardship question. And one of the things that I'd say is really interesting about infringement offences, and Chris might have a view, but we don't really know how they're used in practice because the information isn't collected, because or it's not something that's sufficiently serious that any issues are readily identifiable. So in terms of where the boundary sits between an infringement offence and a prosecutable one, I think that our responsibility to not just try and design the system well, but to understand how it operates in practice over a period of years helps us to potentially recalibrate if necessary. But yeah, Chris might have other thoughts.
I agree with that. As Sam said, the effectiveness of infringement regimes is a little bit, there's no kind of central place where we monitor that. Each agency will hopefully know whether its infringement regimes are working. With the Ministry of Justice, the only thing we see is when we're enforcing all of the fines at the end when it hasn't gone as well as it should.
Yeah, I wonder whether I can pick up that theme though too, because you've touched on this a little bit. I mean, what are the legal consequences if someone breaches an infringement notice or fails to pay the infringement fee, Chris?
So that's what I was talking about earlier, which is when the prosecuting authority files it with the court for enforcement, then you open up all of these enforcement tools that the courts have for enforcing a court fine. So yeah, you're seizing property, your attachment orders, things like that.
Yeah, but it's, in some senses the infringement regime still stays in place. It's still got some. It's not the same as a conviction. I guess is where they're getting to. But I think as you're starting to report, you can, but potentially if you don't pay this and it compounds, then you end up in some other difficulties which are breaching some other statute in some senses as well. I mean, it might even lead to bankruptcy in some of these cases. So that's another sort of issue in here. Sam, can I just turn to you briefly? There's quite a lot in terms of just the level of the fee. And we've touched a little bit in our conversation about adjustments for inflation, but still having the infringement fees is a relatively low level. Someone's also touched on the idea that apparently exists in Finland, where some of these infringement fees are set as a proportion of income. I guess that's getting to some of the stuff that Chris has talked about. Can you just talk briefly to address some of these questions we've got about the levels of those infringement fees and how they get changed?
Yeah, and I think those are both really interesting examples, and particularly about an inflation adjustment. The fact that the maximum amount of the penalty has to be set in the legislation is, firstly, obviously, that creates some complexities around an inflation adjustment. How that can go is if you set the maximum through the legislation, and the Financial Markets Conduct Act is an example of this, where the maximum is set in the legislation, but there's a schedule in regulations which sets the amount for each of the infringement offences. That can make it somewhat easier to operate for inflation. But I think generally the idea of an automatic annual uprate for inflation, there's some significant benefits to that, but there's also some complexities. It would be administratively complex to do that across such a large number of regimes.
So you've got to think carefully about that, right?
Yeah. But I think the flip side, of course, is, and I think I'm not sure if the Litter Act is the oldest one. Is it? Maybe that's 1979 and hasn't been updated, perhaps. So the maximum amount of the penalty can become out of date over time, and of course, an amendment bill purely for that purpose is unlikely to be kind of warranting house time. So it is something that is a difficult balancing act, and the needs to have clear and accessible law that lets people know what the penalty for the offence is probably mitigates against that idea of an annual uprating.
Yeah, makes sense. We've just about run out of time. I'm going to sneak in one last question, which is for Chris. From a Ministry of Justice perspective, when should the details be in the Act and when should they be in regulations?
Okay, yep, good question. So as long as you've got the structure in the Act, and often what you'll see is, so infringements tend to draw on what's already in the Act. So if you've got offences in the Act, usually what will happen is the regulations will say the offence under this section is also an infringement offence. So you don't want to generally be creating offences. You don't want to create offences in the regulations. You just want to do things like identify which offences are infringements, and then set thing. Yeah, it may be that you start off with your Act and it has a whole bunch of offences. The first time round, you identify 5 of them to put in regulations as being infringement offences. Later on, you realise actually there's a few more that we could probably use infringements for, and so putting that in regulations makes it a lot easier. You don't have to go back through Parliament in order to make these other offences infringements. And also, of course, the penalty level, when you can adjust the penalty level without having to go through that whole process.
Within bounds.
Yeah, within bounds, always within bounds. So yeah. Main point is, the structure should all be in the Act, and then just the detail is in the regulations.
So that's really helpful. Hey, we've now come to the end of our time. I want to thank everyone for attending today, and thanks to our panel members, Chris and Sam. There will be a survey appear on the screen shortly. If you could just, before you leave us, fill that survey in for us, that'd be fantastic. Today's discussion's focused on the careful design of infringement offence regimes. These offences can be effective, but only when they are used for the right type of conduct and supported by clear, proportionate and workable legislative settings. We'll send some notes from today's session with a checklist, the one that Sam talked about, that we hope you'll find useful. We also encourage you to look at Chapter 25 of the LDAC legislation guidelines and also Chapter 22 on compliance and enforcement, because infringement offences should always be considered as part of the wider regulatory toolkit. The short poll, as I referred to before, is on your screen now. We'd really love to complete it. It gives us feedback on the session and to suggest topics for future webinars. If that poll isn't showing, please access it through the chat before you leave. Our next webinar will be in September. And we'll be we'll be a back to basics session on international law. Later in the year, we'll also be doing a webinar on delegated lawmaking powers, which touched on some of the questions we've talked about today. So thank you again for being with us. We look forward to seeing you next time. Ka kite anō.